The courts have accepted that some innocent people may have been sent to prison for non-payment of council tax, but that doesn't make the system unlawful. Welcome back. We are talking about council tax once again, and I've got our learned friend Alan Robertshaw with us. How are you doing tonight, Al?
I'm doing very well. I am now dry after venturing into very soggy Truro.
So Al has sent me a link to the statistics from a Freedom of Information request, which shows that on hundreds of occasions, 692 cases have resulted in a jail order. And Al will talk about the difference between jail and imprisonment in a minute. And 773 people may have been jailed, and 10,000 odd given deferred jail terms. Talk to us about that, Al.
Yeah, well, first of all, just to do my sort of like legal trivia thing, the distinction between jail and prison is prisons used to be where you were sent to be punished for criminal offences, whereas jail, and I like the original spelling, you know, the G-A-O-L spelling, jails were for people who not necessarily have been convicted of offences, well, criminal offences. So, for instance, if you are found to be in contempt of court, and even though they will say you are committed to prison, technically that's a jail sentence because it's not a criminal conviction. Theoretically, when you're being held on remand, you are in jail. You are not in prison because you have not yet been convicted. Now, we don't have the separate facilities now, so all jails are now located in prisons, but not all prisons actually have jails. Some prisons are specifically just for convicted prisoners serving their sentences. But because failure to pay council tax technically is not a criminal offence, you are not imprisoned. You do not receive a sentence of imprisonment for it. You are merely given an order committing you to prison. Now, obviously, when you're sat on sort of D-wing in Brixton Nick, that might be a distinction without a difference. But just in terms of the terminology, that's possibly something to understand. And this is the whole problem with this, because we use the same word to describe different things, and sometimes we use different words to describe the same thing. Like a liability order, and I know there's been a lot of controversy about this, and it actually says in one of the judgments, a liability order is, when it's been made, it's technically more akin to a judgment. But when the council just issue a liability order, arguably it's just more akin to a claim, and I think that's why there is a lot of confusion about this. But the upshot is that at least 692 people were definitely ended up in prison, and 7,990 people were given the equivalent of a suspended prison sentence. In other words, it was a deferred commitment to prison, and it might be that the actual figures were even higher than that. But yeah, we do know that a lot of people have ended up in prison. And the thing that Danny's going to talk about, because he's the actual lawyer, he knows about the law as opposed to all the trivia stuff, is how that comes about, and the various cases and the problems inherent in the system. And whether the system itself is unlawful.
Indeed. And so there's the distinction there between unfair and unlawful, and they've been argued back and forth. And just before we touch on a case which did draw a specific analysis between those two and a conclusion between those two, we'll refer briefly back to the case I mentioned in yesterday's video, which is this one here. So big thanks to the e-scribers who actually put this transcript together. It is Crown copyright, but we're using it to comment on it for education purposes, review, and so on. And that's in accordance with the legislation. And it is available to the public somewhere. So let's just have a look at one of those bits here. So for those that aren't familiar, this case was essentially someone going to court to say that these debt collectors coming to enforce a liability order didn't have the correct paperwork and shouldn't have done so. And so he raised various claims, including harassment. Just to correct some people's understandable misunderstanding in the comment section, the harassment part of it failed. So he was awarded £4,000, but it was not for harassment. It was for various other things, as to the tort, essentially, the wrong of not doing things properly, a breach of the regulations. So that's essentially what the case was about here. And along the lines of what you've just said, Al, with this being akin to an order, the judge here said that this liability order is in a way, and I'm reading from the blue section here, is in a way a misnomer, mislabeled, wrong use of the term to cause some confusion, because we would normally associate that with a physical order that you can then go and enforce. But, as the judge comments here, no order is ever actually produced. Rather, someone turns up from the local authority and presents a list of names, and anyone that does appear, who's summoned to appear, have their day in court. They have their say. They can make their own representations, or they can instruct a lawyer to do it for them. And this is also why they have a room. And Al, I think you've got some interesting stories about rooms in just a second. But that's essentially why they have a room, because it would make sense. Because on any one of these hearings, there could be hundreds or thousands, typically, of named defendants who allegedly owe council tax and haven't paid it. They're summoned to appear, and so they call them up one by one to have their say, many of whom just don't appear. And for that reason, it is done as a list, and I presume that the doing away with the prescribed order that was previously used was because it was so onerous on the court doing this thousands of times that eventually somebody just said, look, let's just have a list of names. We'll give them all the chance to make their representations. Otherwise, we'll sign it all off. And then it goes back to the council. The council then have deemed liability orders against all of those named individuals. Al, what was it you were telling me about rooms in courts before we started recording?
Yeah, I mean, this is because I've done quite a few sort of. I'm not a council tax expert, but I'm not an expert in anything. But with sort of things like business rates, because I do some corporate law, we get into all sorts of confusions about, the classification of buildings, what the VAO says. Where, a lot of our arguments are this building hasn't been signed off yet, so it's not liable for any sort of tax. Or actually, could you reissue that order, but in the name of a different company because, it's been through 57 hands by the time it's got here. But when you actually attend court, in court, first of all, the local authority, I'm not going to say council because I'll get mixed up with council. The local authority is represented in court by, a lawyer. But also outside of the court, there's usually somebody there from the council who's, because effectively the council is, the client and the lawyer acts on their behalf. But you have a representative from the council. Now, when you go to court, there are lots of rooms available theoretically. Because so you can have somewhere quiet to have a chat or a conference. And if you attend a magistrate's court, for instance, on a speeding matter, your lawyer might say, "Do you want to shall we just try and find one of the interview rooms and have a chat about it?" I mean, a big complaint with the collapsing court system is that those rooms are either not available or being used for storage. And what you'll find is, sometimes, for instance, the probation team will hog one of the rooms, or the, child protection team will hog one. But those rooms, when you do a council tax or a business rates day, the local authority representative, not the lawyer, just the representative, they will take over one of these rooms. And we'll usually go in and meet them beforehand and say, look, this is the issue. And usually it's something very highly technical, like, actually, can you issue it? Or we can prove that this is not liable to these particular business rates or something like that. And you'll sort that out between yourselves. And a lot of the time then they'll say, okay, I'll let our lawyer know and you can go now, because they'll pass that on to their lawyer saying, this matter you don't need to deal with today because we're sorting it behind the scenes. So when people say, oh, they hire the courts and they have their own rooms. No, they're just bringing cases. I mean, if you issue a private prosecution, you don't pay anything. but you get the use of the courtroom and you get the use of the magistrates and all the facilities. It's one of the few things that's actually still free in this country. I mean, the civil justice system is supposed to be self-funding, and that's why you have issue fees and trial fees and listing fees. But yeah, there's nothing particularly sinister about the mere fact that somebody from the local authority will be sat in a room, because, you know, if you go to a court on a non-council tax day, just a regular day, you'll find people sitting in those rooms all the time. It just makes sense for the court staff to say, okay, you hog that room for the day, because it's the old cliche that a lot of the time, so long as you actually turn up and sit down and engage with people, you can usually buy yourself time. I mean, one of my favourite judges always used to say, when it came to things like possession orders and things in the county court, he said, you get 28 days just for turning up.
Exactly, and it's the same in any other kind of case, really. I did a lot of family work, and it's exactly the same. You find a room, you actually sit down with people, and more often than not, I would resolve issues before we go into court. And there's nothing better than a lawyer that turns up to court for a judge that says they've already sorted it out, we just need the judge's ruling on one point, and, you know, you please the judge, you please everybody. So coming back to this point here, so this procedure of the local authority turning up with a list and then that being produced, then what happens then, what happened in this case at least, and dare I say it probably happens everywhere, the defendants, who, just to be clear, was the debt collectors, not the local authority, a point that the judge kept coming back to throughout this judgment. The defendants on the evidence just took the local authority at their word that this list of names had liability orders made against them, and it was signed by the corporate income manager of the local authority. They took them at their word and they went on to try to enforce it. Now, the judge said further down that the way that these liability orders are made is potentially problematic. And I think that's putting it mildly. The claimant in this case argued that the whole thing was defective and therefore that no liability orders were made. And if they were, they shouldn't have been for various other reasons. And that's another point that the judge referred to, because there's no obvious route of appeal, because with a judgment, you have a specific document telling you who pays what, when, and how. And you can go and appeal that in the usual way. But with a liability order, which is essentially deemed to have been made by the magistrate approving a list of names, is not as firm as a judgment that you can then go and appeal. So anyway, this judge found that problematic. However, it's been inferred by some that that means that there is no liability order, that they're not enforceable, etc., which is not the case. The judge didn't find that. The judge said, and the green bit, I think it here is, the last green bit here, the judge says, if I ask myself on the balance of probabilities whether the magistrate's court on the dates shown made liability orders against those persons on the court list, then the contemporaneous documentation suggests that this was the case. And then goes on to say, insofar as the claimant in this case gave evidence that his recollection was that no order were made, he must be mistaken. So he said, I don't remember them ever doing that. The judge said, well, you must be mistaken. I prefer the evidence in the documents which says that those orders were indeed made. So ultimately, that's what was concluded there. And the harassment bit fell away. But there was another case that actually compared the unlawful versus unfair points, which I'm just going to try to bring up now, which is this case here. This is a slightly older case, not all that old, considering it was in the High Court. So if I can flip to that, so I'm looking at the same thing as the screen. So again, full citation. This is a reported case, because what we mean by that is it's reported in ordinary law books that we can go and look up on libraries, as opposed to a transcript that we just had to find. But essentially, this is a judicial review. Al, do you want to talk a little bit about judicial review so we mix it up?
Yeah, I'll just talk briefly, and I'd just like to get on record that whatever we are actually doing at the moment, it's certainly within Section 30. Well, whatever we're trying to do is within Section 30 of the Copyright Design and Patents Act 1988. So this is review, criticism, or commentary. But judicial review, please see my video in the Collapsing Church. But judicial review is a way of challenging the decisions of public bodies, whether that be the government, quangos, local authorities, even courts in some circumstances. And what you have to show is that a decision was made that is unlawful. And it can be unlawful because the body just didn't have the power to make such a decision. That's what we call ultra vires, outside the powers. More often, though, you will argue that the decision is something called Wednesbury unreasonable. That's after a case, Wednesbury Picture House. And the test there is that the decision is such that it's not just that it's a different decision to the one the court might have made. It's a decision that no reasonable authority could have made. It doesn't matter if most authorities would have made a different decision. It has to be so outlandish that nobody could have made it, which is obviously a very high threshold. And quite often courts will say, well, actually, even though we would have come to a different conclusion, they, as a matter of law, were allowed to make that decision. But it can also look at unfairness. And unfairness is things like not taking into account a factor you should have taken into account, or taking into account a factor you shouldn't have taken into account. And what the challenge here was, they were saying, back to, like that other thing, they were saying, look, people are being sent to prison. And this was actually a Welsh claimant who had been sent to prison. And her argument was, well, the system was just so confusing. I probably had a defence to this case, but I got sent to prison. And, the Citizen Advice Bureau is available, but, there's no legal aid or anything like that. And the conclusion is, and Dan will sort of take you through the law, I was just setting you up there, Dan, but the decision effectively was, actually, probably some innocent people, because the argument was some innocent people are clearly going to prison when they actually had a defence. And they were saying courts are making the wrong decisions because magistrates don't have the requisite training, or the legal advisors don't have the requisite training. And the court basically went through and said, well, look, a lot of what you're saying, I'm not disputing necessarily all that. But the issue here is the system unlawful as a whole? And with regards to, for instance, the lack of legal aid, they said that's a separate challenge. That's a challenge to, because there had been a case, sort of Howard League for Penal Reform, where they'd said, in another matter about people in prison, saying people in prison have difficulty accessing lawyers. And they were successful in that. They said, they should give lawyers. But they said, your challenge effectively is that there's no legal aid available for this. So people are having access, difficulties getting proper legal advice. And more importantly, somebody to do the research for them into their individual case and somebody to argue their case. But they said, that's not something we can consider. That's a political decision. So the upshot was that they acknowledged that, on individual cases, sometimes, magistrates got it wrong, or legal advisors got it wrong, but they said, look, the remedy there is that you can appeal decisions, or, wrong decisions. There is a regular appeal route. So they said, you should not have brought this by way of judicial review, because judicial review is to challenge the system as a whole. You basically should have just brought an appeal in your own particular case. But what's sort of, I suppose worrying is that they said, we acknowledge that individual mistakes are made. We accept, we don't rule out that mistakes are made. But the system as a whole is not unlawful, because just because the law is, hard to understand, and just because occasionally people make mistakes, and just because it's very hard to get lawyers these days, that does not make the system unlawful. But what's very interesting about this was actually a case brought by, even though it was, sort of in England and Wales the courts don't really, it's just one jurisdiction. But because the Welsh Assembly, effectively the people enforcing council tax in Wales, they took a decision on the back of this case and said, we will never ever seek imprisonment or suspended imprisonment for failure to pay council tax. So that's a very different position to what we've still got in England. So it was interesting. The court said, this is possibly unfair, but it's not unlawful. And the actual Welsh government said, actually, okay, we even though we could carry on as we have been doing, just maybe for political reasons or just out of fairness, as I said, okay, we will no longer seek imprisonment for people because we accept that some people, especially people who just don't have financial resources, are getting the ultimate penalty. Because, like you say, it doesn't really matter. It's technically not. You're not technically, being sentenced to prison. You are just getting a jail order. It's like, well, great. It makes no difference to me. So yeah. So now, feel free not to. And what's interesting is they've monitored this because this was in 2019 by the time it all came through, and actually not removing sending people to jail as an option has not affected council tax recovery rates at all.
And I suppose that's right, because I suppose people that are going to pay it are going to pay it, and the reverse. And so all of this starts, of course, with the Local Government Finance Act 1992. People very often ask, where is the liability to pay it? It's here in black and white. It describes at Section 6 the person's liable to pay council tax. So for any dwelling where it is applicable, it goes through a list and encompasses whatever your position in the property, whether you own it somehow or live in it, whether you're liable to it, unless, of course, there's an exemption that applies. So moving back to this case here, as Al described earlier, this claimant here said that the system was unfair and unlawful. So it's an important distinction where the claimant here claims that it was both unfair and unlawful, which, of course, is not necessarily going to be the case. It might well be one or the other, or both. As Al described earlier, the court ultimately said it might be unfair sometimes, but that doesn't make it unlawful. What the court did do as well in this case is to summarise, much like we've described before, the liability order itself and how it's similar to a judgment. The court said liability order confirms the amount of outstanding debt, the identity of the liable person. It is in many ways the equivalent of a judgment, which can be enforced in any of the ways set out in the regulations. And those include an attachment of earnings order, which is where money is deducted from your earnings by your employer before it gets to you and it's paid over to a creditor. Applying for sums to be deducted from certain state benefits or potentially, and I think, is it right, Al, that they can do any one of a number of these in combination? I believe most enforcements are done in any combination. I think that's right.
Yes, it's rather strange with council tax because although the sort of liability order, or whatever you want to call it, is made in the magistrates' court, the enforcement aspects of it can be just done in the county court with all the normal county court enforcement stuff. So that's attachment of earnings, garnishing, going after bank accounts, sending the bailiffs round, sending it up to high court enforcement. But yeah, they can put all this in. But like I say, the key thing to remember is that the issue here wasn't that there may have been individual unfairness in particular cases. It was whether there's procedural unfairness. In other words, the system as a whole is so unfair. That's what makes it unlawful. The mere fact that occasionally it is unfair or it's unfair to particular people doesn't make it procedurally unfair. And I can understand why people get confused with the language of the law, because it's like, no, we didn't mean unfairness in that sense. We meant it in the other sense.
And that's where the court came to in this point here, which is where the court said persistent errors in applying the law by magistrates might evidence unfairness as a result of a deficiency in the relevant scheme's procedures. So, and it goes on to say, for example, they might not have been trained, there might be budget constraints on the training, etc. So, in other words, if they get it wrong consistently, that might make it unfair. But it's not to say that the system is unlawful. And that's essentially confirmed down here. It doesn't mean the system is unfair, even though they might get it wrong sometimes, and even though people might be sent to prison sometimes on the basis of it being wrong. So I know that was a bit of a longer, more chatty video around this subject, but I think that was necessary, certainly judging by the comments on yesterday's video and videos gone before. And don't forget to check out Al, when is your judicial review video going up on Art of Law, which is linked in the description below for you to all go and subscribe to?
My judicial review video is already up, and it's the one I recorded in the collapsing church. And then, I nearly said the name of the person whose land I was on. A certain person came and very kindly just went, "Oh, you shouldn't be here." But the great thing about that is, somebody then asked in the comments, if that church had collapsed on you, could you have sued that landowner? And, so that gave me another video on the back of that. But what I am going to do is a video on what we call the single justice procedure, which is very much related to this, because over 500,000 cases a year are dealt with without anybody going near a court or having any sort of hearing, and it's literally one magistrate sat in a room with the legal advisor and a stack of papers like that, just signing, and because it's used for road traffic offences, TV licences. Also, I won't spoil the video by giving it away now, but it is sort of related, and this is a bit of an issue as to, just the idea of, bulk, wholesale justice. But this is the future. When you issue a claim in the county court business centre or money claim online, yes, technically that is a court, but it's literally just one district judge just sat in a room somewhere up in the Midlands.
Well, indeed, and that does answer some other questions that I've seen more than once in the comments as well. That this, did you know this isn't a proper court? Well, it might be a room somewhere. That doesn't mean it's not a proper court. I mean, in the lockdown and such things, the courts have sat in all strange places. I think was it a Holiday Inn? One of the hotels, anyway, became the county court for the day. And there was a sign outside saying "sitting at the Holiday Inn" or whatever it was. So there we go.
It literally was. It was the local Holiday Inn. But this is not uncommon. Just to drag it down and do more trivia, in the Great Train Robbery trial, because there were so many defendants and so much public interest, they couldn't actually hold it in the local courtroom. So they just had it in the local sort of civic hall, just because, where they'd normally put dances on and things like that, just because it was big enough to accommodate everybody. And when they had to sentence them, they went back to the Crown Court for sentencing, but they could only bring people up one at a time, or most two, because of the size of the dock. And because all the other train robbers hated Ronnie Biggs, they all pretended that they'd got a lower sentence. They all agreed that whatever sentence they got, to say they'd only got half of that. So they're coming out. So what happened? It's like, I got 15 years. I got 15 years. And then Ronnie Biggs came up going, and you will go to prison for 30 years. And apparently really kicked off because, hang on, why am I being treated worse? I only hired the train driver. So there you go, a little bit of trivia. I always like to drag Dan's videos down with the rambling and the tangents.
Wouldn't have it any other way, Al. So we hope you found that interesting. Do check out Art of Law, linked in the description, which has already your judicial review and the upcoming single justice procedure video. So thanks for sticking with us. If you've stuck with us that long, thank you. I applaud you, and we'll see you next time.